Welcome to this short course on parallel proceedings. Parallel proceedings happen when one violation does not stay in one enforcement lane. A single fact pattern can begin as a routine pretreatment enforcement matter, but later involve administrative, civil, or even criminal pathways. For pretreatment staff, the important point is not to become a prosecutor or investigator. The important point is to recognize when the facts may carry more weight than a typical notice of violation. This field note is about protecting the record, preserving options, and understanding when coordination matters. One violation can become more than one case, especially when the conduct appears intentional, deceptive, or dangerous. Pretreatment staff are often the first people to encounter the facts. You may be the person reviewing the self-monitoring report, walking the facility, seeing the discharge point, or noticing that the paperwork does not match what is happening in the field. That first contact matters because early decisions can protect evidence or damage it. Good notes, clean documentation, proper sample handling, and careful communication can preserve enforcement options later. Parallel proceedings are not about overreacting. They are about professional discipline. When a case may cross into a broader enforcement track, the safest approach is to document clearly, stay objective, and bring the right people in early. Parallel proceedings occur when the same underlying conduct is addressed through more than one enforcement path. Those paths may move at the same time, or they may happen in a coordinated sequence. For example, a local program may issue an NOV or compliance order, while a civil penalty case is being evaluated. In more serious cases, the same facts may also raise criminal referral concerns. The key is that each path has a different purpose, different tools, and different legal standards. Pretreatment staff do not need to manage every path, but they need to understand that one set of facts can support more than one response. The administrative lane is the one pretreatment staff usually know best. This includes notices of violation, compliance orders, permit actions, administrative penalties, and other tools designed to bring the industrial user back into compliance. The civil lane is more formal. It may involve court-backed remedies, injunctive relief, penalties, or cost recovery. Civil enforcement is often used when a stronger remedy is needed to compel compliance or address harm. The criminal lane is different. It is generally connected to conduct, such as knowing violations, false statements, tampering, concealment, or fraud. Pretreatment staff should not threaten criminal action, but they should recognize facts that may need escalation. Some violations stay within normal program enforcement. Others carry red flags that may widen the case. Unauthorized bypasses, hidden discharge points, or concealed waste streams should immediately raise concern. False reports, altered logs, misleading certifications, or tampering with sample points are especially serious because they attack the reliability of the compliance record itself. Repeated significant noncompliance after formal notice can also change the posture of a case. When the facts suggest intentional conduct, deception, interference, pass-through, or worker safety impacts, the case may need coordination beyond routine enforcement. When a case may become more serious, the first responsibility is disciplined documentation. Write down what you observed, when you observed it, who was present, and what records or photographs support the observation. Preserve the original record. Keep photos, emails, logs, reports, inspection notes, and sampling records organized. Maintain chain of custody and sample integrity so the data can be trusted later. Then follow the program. Use the ERP, notify supervisors, involve legal counsel when needed, and coordinate with the approval authority, state, or EPA when the facts warrant it. Stay objective and stick to what can be verified. There are several things pretreatment staff should avoid when a case may involve parallel proceedings. Do not threaten criminal action. Do not speculate about motive, guilt, or what another agency may decide to do. Do not alter notes, rewrite observations to make them sound stronger, or clean up the record after the fact. If something needs clarification, document the clarification separately and preserve the original. Also avoid side investigations outside program protocols. Do not casually discuss sensitive case details, and do not use routine inspection authority in a way that creates confusion about the purpose of the visit. Coordination usually begins with the local program discovering an issue that may come from sampling, an inspection, a complaint, a report review, or a pattern of violations that no longer looks accidental. From there, the matter should move through internal review. Supervisors, program management, and legal counsel can help decide whether the case remains local or whether the approval authority, state, EPA, or another agency should be contacted. The goal is coordinated strategy and clean communication. Facts should move through approved channels, and the boundaries between inspection, enforcement, and investigation should be preserved. Consider a metal finisher with repeated cyanide violations. At first, this may look like a standard pretreatment enforcement matter: violations, an NOV, a compliance schedule, and follow-up monitoring. Then inspectors discover a hidden hose bypassing pretreatment. At the same time, self-monitoring reports continue to certify compliance, and operator statements do not match the records. The case is now changed. Administrative enforcement may still be appropriate, but the same facts could also support civil penalties or injunctive relief. The hidden bypass, certifications, and possible concealment may also create criminal referral concerns. The main takeaway: one fact pattern can support more than one enforcement path. Pretreatment staff do not need to control every path, but they do need to protect the record. Your role is to document, preserve, escalate, and coordinate. Strong records protect both compliance and enforcement options, especially when the facts look intentional, deceptive, or dangerous. Parallel proceedings are about discipline, not overreach. Protect the record, follow the program, bring in the right people early. That is how a pretreatment program handles a serious case without damaging it.